Welcome, everybody, to today's Legal Topics webinar with Chris Goss. Our topic today is personnel questions and laws. We get lots of questions about personnel and the legal implications. So we're excited to bring this, the next in our series. This is our sixth. We have one more session scheduled coming up next week about public meetings. And so as we look to the upcoming year and our schedule for further topics to discuss, be thinking maybe you throw into the chat some other legal topics that you might want to learn about. But with that, and with not much further ado, we do want to remind you that you need to consult with your own attorney for local legal questions. And this is offered to you for informational purposes only and does not constitute legal advice or opinion. So your questions are really important. Add those to the chat. And with that, I'm going to stop sharing, Chris, and give it right over to you.
Thank you. It's great to be back after a little bit of a delay. This is a topic that we could probably spend a couple days on, and something that I'm hopeful will provide you with, again, some reassurance that you're handling things in the right way, or if there's been a lingering question in your mind, perhaps pointing you in a different direction or new direction. And it's our hope, as always, to provide just a foundation of knowledge to get some general ideas about the statute, becoming familiar with where to find those statutes, what they say, and then what those statutes can do to play a role in personnel policies, handbooks, contracts, and evaluation in personnel files. And so that's our hope over the course of the next hour, is to just build that foundation of knowledge, provide that reassurance, and let you know the right path to choose and when you're talking to county or municipal human resources departments about those human resources issues, personnel issues that you might be encountering. I always want to start at the beginning with the board authority for each of the types of libraries in Montana. In 22-1-310, you have a statute regarding the free libraries of the state. The chief librarian personnel compensation board has that authority to appoint and set the compensation of the chief librarian, who would then in turn provides recommendations to the board to employ and discharge other such persons may be necessary to complete the affairs of the library. The library board then has the authority to fix and pay the salaries and compensation and prescribe those duties. And this has been a statute that's been reviewed by the Montana Supreme Court and affirmed that that's the role of the library board. And it's important for interlocal agreements between libraries and municipalities or counties to honor that statute and set forth how the library board will comply with the statute in consultation with the human resources personnel within the municipality or the county or other local government function, and making sure that that authority that's expressed in the statute is handled so that the library board governs that library consistent with the law. The library districts that are established elsewhere in Title 22, 22-1-707, the duties and powers of a library district board would be the powers necessary for the betterment and operation of the maintenance of the library, the property, and that includes the authority to employ or contract with administrative, professional, or other personnel necessary for the operation of that library district. And taking it a step further, you have that specific authority specified regarding contracting with other entities that may be necessary, and that could include those that provide specific services, vendors, including areas of human resources, to make sure that the services of the library are completed and executed in a manner consistent with the purpose of that library district. So using those baseline statutes and the authority that library boards have regarding personnel, we get into um, some more statutes, more generalized statutes that govern uh, personnel of local governments, as well as general employment relationship laws in the state of Montana. The Wrongful Discharge from Employment Act, something you've probably heard of, reviewed, have awareness of in Title 39, the general labor laws of the state of Montana. In 39.2.902, it outlines the purpose of the Wrongful Discharge from Employment Act, which would apply to the employees of the library, in making sure that the rights of those employees are honored and that they are uh, uh, the rights of the employees are protected, but also providing remedy for those employees to pursue enforcement of their rights consistent with the law. It states that a discharge from employment is wrongful and outlines how that can occur if it was in retaliation for employees' refusal to violate public policy, if discharge was not for good cause, and if the employee had already completed their probationary period, which we'll talk about in the next slide. The employer materially violated express provision of its own personnel policies prior to the discharge, and that the violation deprived the employee of fair and reasonable opportunity to remain in the position. The employer terminated the employee solely on the basis of the employee's legal expression of free speech, including but not limited to statements on social media platforms. During the probationary period of employment may be terminated at the will of either the employer or the employee in notice to the other for any or no reason, and that the employer has the broadest discretion when making a decision to discharge any managerial or supervisory employee. So you start to see the framework that the legislature has established through the Wrongful Discharge from Employment Act to balance the rights of employees to know how they're going to be treated, to have some expectation of consistency and stability in their employment, but also honoring the rights of employers and to make decisions regarding the makeup of their staff and the people who are delivering services within the scope of their operations. But you see a couple of keywords here, especially in 1C. Please pardon the heater that's being kicked on here at the college, and I'll just pause for a second.
Chris, I think you're good. It's not coming through.
Thanks. That it was a little loud, but the employer in 1C, the employer materially violated express provision of its own written personnel policy prior to the discharge. That's an important provision because it sets forth an expectation that there will be policies, there will be personnel documents. And so when you look at that provision and combine it with the definition of good cause in 39.2.903, you look at any reasonable job-related grounds for employees' dismissal based on the employee's failure to satisfactorily perform job duties, the employee's disruption of the employer's operation, the employee's material or repeated violation of express provision of the employer's written personnel policies, or other legitimate business reasons determined by the employer while exercising the employer's reasonable business judgment. And so you start to see again the need for personnel policies, the need for handbooks and governing documents, and having that foundation of mutually understood expectations is an important aspect of an employment relationship. And it honors the employee's rights, but it also can help protect the employer in those situations where there is a need to separate from the employment relationship. And having that policy and having those expectations clearly outlined can go a long way in resolving any potential dispute. There are some exceptions to the Wrongful Discharge Act, and those are important exceptions. The first is the does not apply to a discharge, and you can see in 2B is our clear guidance, or 1B rather. The employee is covered by a written collective bargaining agreement or a written contract of employment for a specific term. So if there is a written contract for a specific term, and taking the second part first, then that employment relationship could be considered expired at the expiration of that specific contract, and there isn't an expectation of renewal at the conclusion of that contract. And um, the legislature has specified, and the Supreme Court has interpreted that to mean that there isn't an expectation of employment beyond the term of that written contract. And so if there's a contract provision that has a specific start and a specific end date, then it can be considered that that contract has expired without an expectation of renewal. That means that it could be renewed, but if it's not renewed, then it's not necessarily considered a violation of the Wrongful Discharge Act. And so to put it in plain terms, a contract with a start and an end date that's not covered by a collective bargaining agreement means that the employee is employed for that term only. And if there is a renewal, then that could be the decision of the governing board. If there's not a renewal, then the employment would come to an end. It's important to contact your local municipal or county human resources staff if you're working with them on these issues, to see the specific nature of those individual employment contracts that apply in your area to determine the applicability of this exception to the Wrongful Discharge Act. If there is not a written contract for a specific term and there's not a collective bargaining agreement, then the terms of the Wrongful Discharge Act would apply, meaning this definition of good cause and the expectation of the employer to follow the written personnel policies and to not engage in discriminatory conduct and the like all would apply. And that means that the recourse the employee would have would be through the state district court to assert that there has been a violation of the Wrongful Discharge Act. If there is a collective bargaining agreement or a written contract for a specific term, then that exemption is triggered and the Wrongful Discharge Act would not apply at the conclusion of that term of that individual contract. So other exemptions, if it's subject to any other state or federal statute, it would be those including claims with administrative bodies alleging discrimination, as we'll talk about in a couple of slides. So the Wrongful Discharge Act is one that all employers in the state must be mindful of. It provides that authority to manage the staff and manage the personnel, and it works to protect employee rights when they're not covered by a collective bargaining agreement. However, there are some public employees that are organized, and they're organized through an exclusive representative, as it's called, their local bargaining unit. And in those situations, as again, you see in 39, 31, 305, again, Title 39 governing the labor laws, if there is an exclusive representative, then there is an obligation of the public employer to bargain in good faith with that bargaining unit. And so when you have employees that have organized and that they have collectively established themselves into a local bargaining unit, and they have established and approved that exclusive representative consistent with the laws and regulations governing collective bargaining for public employees in Montana, then that triggers an obligation for the public employers, you see in subsection 2, to meet with the representatives of the bargaining unit, the exclusive representative. And you can see in some key phraseology here in subsection 2, to meet at reasonable times and negotiate in good faith with respect to wages, hours, fringe benefits, and other conditions of employment, or the negotiation of an agreement or question arising under an agreement and the execution of a written contract incorporating any agreement reached. You could put a team of lawyers working for years, as has happened, on what those words mean. But what they generally mean is that you have an obligation as a public employer to work with an exclusive representative as designated by the employees who have organized to meet and confer in bargaining good faith on those issues related to wages, hours, fringe benefits, and other conditions of employment. And that can include a whole variety of different topics. And so once you have that agreement in place, then that would result in a written contract, a collective bargaining agreement that binds both sides to the terms therein. So it's probably Not as many libraries in Montana have this this obligation. Those that do are working with their local human resources professional and their local council to engage in those negotiations and to work with the designated bargaining unit representatives to bargain in good faith for those terms of employment. So just important to be mindful in that relationship, then back to the Wrongful Discharge Act. If there is a collective bargaining agreement and the terms of that agreement will govern it rather than the procedure set forth in the Wrongful Discharge Act, meaning the employee would follow any grievance procedure or any protections or procedures established in the bargaining agreement as their exclusive remedy instead of the Wrongful Discharge Act. Another set of concepts that relate to employment law for public employees, and specifically those in local government, is the Governmental Code of Fair Practices. And the Governmental Code of Fair Practices is going to bind the library to honor the rights of the potential employees and current employees with regard to their employment status, and making sure that their employment status is based solely on merit and qualifications. And so you can see in this statute that state and local government officials, supervisory personnel within those local government agencies and entities shall recruit, appoint, assign, train, evaluate, and promote personnel on the basis of merit and qualification without regard to those designated protected classes, as you see in your non-discrimination policies and in other aspects of Montana law, meaning that membership in one of those protected classes is not going to be the determining factor for someone to get a job, or someone to get a promotion, or to someone to be eligible for training. Instead, it's the merit and the qualifications of that applicant, whether they can be considered to be employed for that position or promoted to a new position, or to receive training, or to have a fair evaluation. That merit and those qualifications are the determining factors. It's not with regard to race, color, religion, creed, political ideas, sex, age, marital status, physical or mental disability, or national origin. Those factors are not the determining ones with regard to personnel decisions in state and local government. So you have state and local agencies shall, and again, you see the requirement for written directives, policies to guarantee equal employment opportunities within state and local government, to regularly review the practices to ensure compliance, and conduct continuing orientation and training programs with emphasis on human relations and fair employment practices. Again, that theme of establishing practices, establishing policy, establishing procedures that comply with the various aspects of the law, whether it be the authority of the library board, the operations of the library with regard to the Wrongful Discharge Act, honoring collective bargaining rights, honoring the rights of individuals to seek employment and gain employment and keep employment within local government without regard to their membership in a protected class. And all of those things are going to play a role in the development of a set of library policies for personnel. Another aspect of library personnel as public employees are the ethical obligations that govern public employees. And the rules of conduct for public officers, legislators, public employees, the key aspect here is to comply with these two sets of codified expectations in 2-2104, and in the next slide 2-2121. So you have this stated right here: public employee may not disclose or use confidential information acquired in the course of official duties in order to further substantially the individual's personal economic interests. Put that in library terms, you're not going to use confidential information, for example, patron information, in order to gain economically from that information. We're going to misuse it in a way that could benefit you financially. B, accept a gift of substantial value or substantial economic benefit tantamount to a gift that would tend to improperly influence a reasonable person and the person's the person to depart from the faithful and impartial discharge of their public duties, or that knows a reasonable person in that position should know under the circumstances, primarily for the purpose of rewarding the person for the official action taken. So substantial gift is defined in the administrative rules of Montana. It's moved up, I think, from $50 to maybe $100. It's set by regulation. So if you accept that gift of substantial value, it would improperly influence a public employee to depart from the faithful and impartial discharge of their duties, then that would be a violation of this ethical obligation. Same concept. If you accept a gift of, if a public employee rather accepts a gift of substantial value, and it was known that it was basically a reward for their official action, then that would also be a violation. So you get into those concerns about someone saying, thanks for helping me use the public employee or the public computer terminal at the library. Here's a couple $100. Thanks for doing that. Now, obviously, that might be a bit of an exaggeration and a stretch, but it's illustrative of how that could be considered an ethical violation if you help a patron at the library with a routine task and then they attempt to give you some kind of tip or gratuity or reward. Then there is that concern that this could be a violation of the ethical obligations. And so it's important to be mindful to not use public employment position as a way to benefit yourself financially. It doesn't mean you can't have other employment positions, but what it does mean is that you cannot blend the two to the point where there is no distinction between what is occurring at the library and what is occurring in your personal financial or commercial operations. And that's goes right to some of the other issues in 2-2121, which is a public officer or public employee may not use public time, facilities, equipment, state letterhead, supplies, personnel, or funds in the officer or employee's private business purposes. You're not engaging in substantial financial transaction for the officer or employee's private business with a person who that person supervises or inspects in the course of their official duties. No public employee is going to assist a person for a fee or compensation in obtaining a contract, claim, license, or other economic benefit from that same agency. And you're not going to assist a person for a contingency fee for obtaining a contract, claim, license, or other economic benefit. When you think about what those all mean, is just getting into that concept of responsible government, transparent government, that the government is working for the people and public resources are being responsibly allocated for the benefit of the public. It's not there to benefit the few or benefit the people who happen to be employed in that public agency. And it's important to remember that we have that obligation as public employees in Montana, not just because it's the law, but because it's the right thing to do. And as public employees, we're invested with making sure information is accessible and that the access to that information is transparent and accountable. These are ethical obligations that we all take very seriously. The public employee is not going to perform an official act which substantially are affecting its economic benefit, a business or undertaking which the officer or employee has a substantial financial interest as a counsel, attorney, consultant, representative, or agent. And so you can see how that would work if someone has a moonlight or a second job as a real estate agent. Can they engage in that transaction with the library where they work? And that would be potential conflict of interest that would have a disruption to the library's operation. Or soliciting or accepting employment or engaging in negotiations or meeting to consider employment with the person whom the officer or employee regulates in the course of official duties without first giving notification of the officers or employees, supervisor, and department director. So if you think about how that could work, if you have someone who is a vendor that works on behalf of the library, it's been hired by the library for a specific purpose to provide a particular service, and that person starts or that vendor starts to recruit library staff to come work for them, and you have a possibility of that ethical issue emerging. So it's important to be transparent and to operate in accordance with the laws. And so this all comes down to making sure that government operates transparently and that public employees are accountable to the public, and that the public's resources are utilized for the purposes for which they were generated and the revenue for which the community and the taxpayers have provided to the library for the benefit of the community. And if those guiding principles are honored, then these ethical obligations are going to generally be satisfied. So we take all these statutes, and as we have done throughout our time this summer, is looking to how we take those laws and translate them into policy that are going to be effective and sound in the operations and supporting the operations of the library and meeting the library's mission. These situations go just beyond a policy. They're going to also include the employment contracts, the job descriptions, the procedures, handbooks, to make sure that the library acts and works on behalf of the community and works on behalf of the public that's paying for that library. And so a sound set of personnel documents is going to build upon those statutory obligations and expectations and the applicable accompanying regulations to make sure that the library administration is executing the board's wishes and consistent with their authority, so that you have an efficient and effective library on a day-to-day basis. Always balancing the rights of the employee to complete tasks that are expected of them with the authority of the board to manage the staff. Those documents are always going to work together. You're going to make sure the contract has the up-to-date job description, that the job description is incorporated and is up to date and reflective of what's contained in the employee handbook, and that the policy sets forth the authority for that handbook, and that they all work together. The last thing you want is for someone to ask, well, what governs here? You've got a conflicting provision in the handbook and the policy, which governs. It shouldn't be a matter of which governs. They should work together. The policy adopted by the board authorizing the director to set forth a handbook. The handbook is a distillation of the expectations as set forth in the policy, and they all work together. So that's how we're going to build that framework and that hierarchy of policy governance and personnel expectations. And so when they're all working together, they're going to legitimize the decisions of the library administrator, be supported by the decisions of the board, and be consistent with the law. So those components within those are going to be outlined first in the interlocal agreement or the bylaws of the library board, and they're going to specify the specific statute that the library board is operating from in terms of its authority to manage personnel. And it's going to then build from there as to which statutes are going to apply with regard to non-discrimination in the Governmental Code of Fair Practices, with regard to honoring the rights of employees through collective bargaining, if applicable, or honoring the rights of employees through the Wrongful Discharge from Employment Act, or the expectations of employees to comply with the public employee ethics, the laws that govern in the state of Montana. All of that then relates and supports the mission of the library, that it's there, as we have used throughout the summer. It's there to make sure that each member of the community is welcome into a secure setting where they pursue their lifelong learning goals, and having that mission embedded within all of those documents, whether it be the policy, the handbook, the job descriptions. All of those work together to support that mission. And when you make a decision then about employee, or you're evaluating an employee, then you have that guidance through the mission statement to help ensure that the decisions of the administration of the library, or the board of the library, are consistent with those laws, that they are supported by the policy, and the policy is being followed to honor the employee's rights while ensuring the mission is met. The employee handbook is always going to have those details that are necessary, consistent with the local and community expectations related to the library. And if there's a collective bargaining agreement, those are going to be embedded there as well. All of that then will be completed in consultation with the partner local government, where applicable, consistent with any interlocal agreement. So what are some examples of what a personnel policy should be? And some of these are general statements. Some of them are taken from the law, but they're examples of how to utilize the law and the mission statement to establish the framework policy, which can then be the basis for the other related documents. And so lay it right out. Library employees are going to honor the law, the library policies in the personnel handbooks. That then sets it right out. You can change the handbook without the need to change the policy. You have that policy authorizing personnel action for violation of the handbook or law. You also, we'll talk about in a subsequent slide, including volunteers here, to make sure that the volunteers, the expectations for volunteers are consistently stated throughout the policy to ensure, again, compliance with the law, and ensure compliance with director and employee directives, while preserving the role of the volunteer in providing services to patrons. But like I said, we'll talk about that in a few minutes, but you can see volunteers listed here in these examples. The policy outlining and incorporating by reference the position description, job description, the employment contract, or the volunteer agreement. They're expected to maintain high standards of honesty, integrity, professionalism, and decorum, and the impartiality in the conduct of library business. Library employees not dispensing any information gained from employment with the library. They're not accepting gifts or benefits or participating in business enterprises that creates a conflict of interest, in the faithful and impartial discharge of the employees' library duties. Library employees and volunteers not using public time. You see that restatement from the public ethics laws with regard to private business, political, or commercial purposes. They are not, library employees and volunteers, not assisting people for a fee. They're not saying, hey, if you want this book, I'll put a hold on it for $5. You're not expecting any kind of fee. You're not soliciting any type of employment or engaging in meetings to get that type of employment, unless you give notice to your supervisor or asking questions about the ethical obligation that can accompany that type of overture from a potential employer. Not disclosing confidential information is set forth in the library patron confidentiality laws that you're all familiar with and that you all honor on a regular basis. And employees are not engaging in discriminatory, retaliatory conduct. And then a general provision for the director designee to set expectations and regulations to govern staff, which would then authorize the procurement of the personnel handbook, and any discipline or redirection of an employee or volunteer occurring because of violation shall be in accordance with any provisions contained in a bargaining agreement, employment contract, state law, or personnel handbook. So you have a general framework within the policy, but it authorizes compliance with other personnel documents. And that's going to include then the contract. And the contract is going to be something, employment contract is going to be something based on likely one of two things. The first being any applicable collective bargaining agreement that governs the employees in the library. And if that doesn't exist and the employees are not bargained, then it's going to be governed by the local government which may be assisting the library. They may have an expectation for specific use of a specific contract, or they may not and may authorize the consistent with any interlocal agreement, maybe allowing the library staff to make those decisions or the library board to make those decisions. It's important to be consistent with any expectations of any partner local government if the interlocal agreement does have a provision about human resources management and how those specific details are operated or completed. But some general areas for an individual employment contract will be of course, the name of the employee, the position which they're being held. So you think of a contract, this person is employed to complete the duties associated with this provision. A term of the contract is going to state it's from this day to this day, as stated in the Wrongful Discharge Act, and going to state whether there is an expectation of renewal. Typically, in compliance with the Wrongful Discharge Act, there would be a statement that there is no expectation of a renewal beyond the period of the specific term noted in the contract. That's a process that you would have to work through with the local library, but being mindful of what the Wrongful Discharge Act says and how it authorizes employers and employees to work on those issues is important to remember as you handle personnel matters. If there is a probationary period, some employers have decided to place the probationary period in the body of the contract. That's a change in the law from what used to exist. There was some confusion as to whether a probationary period would nullify a term contract. The legislature changed that to say that the probationary period may be embedded into the body of the agreement. If there is a probationary period for the employee, it can occur within that contract, or it can be a separate document that says you're employed for this probationary period. And then at the conclusion of the probationary period, there's either a termination of employment for any or no reason as authorized by the law, or there's an issuance of a personnel contract at that time. There's one of two ways to handle it. Either way, making sure that it's honored and respected, consistent with any local government requirements or library board decisions. Then there's an incorporation of the job description by reference, meaning that it's stapled to that contract. And think about a physical piece of paper, or it's embedded within the electronic document stating the attached job description for the position noted above is held by the employee, is incorporated fully by reference, and the employee shall complete those duties as assigned within the scope of that job description and complete the assigned roles and duties to the best of their ability. So you have that job description specified, written out, and incorporated into that agreement. That leads to an important point of having job descriptions for each position within the library, and to have those regularly reviewed, just like you review policies, and to ensure that there is a clear understanding of what the role is and what the expectations are for that particular position. And then it provides not only a basis for compliance in terms of the contract, but it provides a basis for evaluation. You're able to use the job description as a method to evaluate the employee's performance. And so in those larger libraries that have human resources support and staff, they likely have these matters streamlined. But in some of our smaller libraries, there may not be that support, and there may not be that understanding of library roles and duties within human resources support from the county or municipal level. And so working with your fellow libraries around the state and developing those job descriptions is an effective way to help with both personnel management and evaluation. If there is a collective bargaining agreement, then that should be mentioned in the contract. There should be reference to the library laws stating the authority of the board to manage and staff consistent with those statutes. Making sure there's a statement that the policies and handbooks and laws are going to be honored throughout the course of the employment. And then it's stating the rate and the schedule of compensation and how that is determined and how it's developed and what it is, and when the individual is paid consistent with any personnel compensation time frame within the bargaining agreement or the personnel handbook. And then any other benefits, whether it be retirement, health insurance, leave will be the other one, and how the leave is set, both in terms of public employee leave that might be governed by Title II of Montana Code Annotated, or other county or municipal developed leave, or the leave that's set forth in the bargaining agreement. And then the provision about the ability of parties to terminate the contract during the term of the agreement, in the process that would be adhered to either through the bargaining agreement or through the personnel handbook following the applicable laws, or the ability of the employee to resign, and what the obligations are for resignation during the term of the employment. So the contract, as you can see, is it's an important document, and it's something that should not be taken lightly because it is a binding agreement. You always think that nothing strange will happen, but strange things do happen. And having a clear contract, consistent policy, and as we'll talk next, effective and appropriate handbooks will help protect the library in the event of some kind of confusion. And that's our hope, is that there is full and comprehensive documents to help avoid confusion that can lead to conflict. That handbook is likely going to be not only a welcoming document to the people who are onboarded, but even for veteran staff, a place you can return to look at. And it's a living document, one that's regularly reviewed, regularly updated to make sure that it is consistent with laws, consistent with the policy, and consistent with current practices, most importantly. So having a handbook is a good first step, but then keeping it updated is an ongoing mission and goal for every library board and administrative leadership. You can see there the different things that could be handled and detailed within an employee handbook, from the mission of the library, the handling of personnel, ethical obligations, organization chart, collaborative leadership, how the administration takes feedback, how it gives feedback through evaluations, how people are compensated, when payday is, how the library operates in specific areas, respecting the rights of employees with regard to health, safety, and security, making sure that insurance is covered through workers' compensation, the health insurance that they might have access to, details about leave, jury duty, other civic type of leave, family leave, the military leave rights, how your personnel files are stored, how you get access to them, how the contents of those, and how to bring a grievance or a concern if there is a need for discipline, how progressive discipline is handled, and making sure that there is a full understanding of the rights of employees with regard to being free of discrimination, bullying, intimidation, harassment, and the ability to resolve those items consistent with applicable federal law or state laws. And so that's a comprehensive document, and it's one that's going to be relied upon by everyone in the library that works there, serves there, works as a volunteer. And so having those provisions in place and having them clarified will be an important step to establishing an employment relationship that's based on trust and transparency and accountability. I mentioned volunteers earlier. Volunteers are an important part of any library's operation. People want to be in the library, they're fond of the library, they want to serve the library, but there's protections that the library needs to take to ensure that the right people are serving as volunteers, and that once people are serving as volunteers, they honor the expectations that come with that that heavy responsibility of being an extension of the library to patrons that are visiting or throughout the community. And so some of the provisions that could appear in a volunteer policy listed on the screen, and we'll be ready to help on any of these types of items. I know it's a common topic around the state as to what that volunteer policy should look like and what type of insurance coverage should be in place regarding the volunteers, both in terms of workers' compensation as well as liability insurance. So it's important to have that discussion with your local government partner and the library's insurance carriers on what that should be and what that should look like. Some general concepts of what the policy can entail can help that discussion with the insurance carrier to ensure that there isn't confusion that results in a wage claim against the library asserting that there should have been compensation provided for years of what the library thought was volunteer service. And so having that expectation outlined and having that agreement signed by the library volunteer goes a long way again to clarifying that relationship and adhering the volunteer to the expectations of the library as promulgated by the library board through its policies. And so some of the concepts, just that you're not going to be paid, that you're not getting medical insurance. There's a schedule for your service to the library, and that's set by the library in consultation with you, but it could be adjusted at any time. It also means that you could be relieved of your duties, and there is not an expectation that you have any right to be a volunteer in the library. And you have to follow the library employees' guidelines. You have to follow the applicable laws and policies that you are going to honor confidentiality at all times. Many libraries have an expectation volunteers have to be 18 years of age or older. If you want to adjust that in terms of some other type of volunteer arrangement, making sure that it's done so in consultation with legal counsel is important. If there is a patron violating library policy, then it's important for the library volunteer to report that. And many libraries have some type of background check that would be required for those that are serving in that capacity in the library to protect patrons, especially potentially minor patrons, from having volunteers that shouldn't be engaging in that type of interaction with vulnerable populations. And so taking those steps to clarify that relationship is important, working with insurance carriers and local government partners to have a policy that is in the interest of the library, interest of the patrons of the library, is important. A level of protection for everyone involved, so that the volunteers are truly an extension of the library, promoting the library's mission in each interaction they have with the patron. Are there any questions?
Chris, there is a question that came in a little bit earlier, but I think it's a good way to kind of frame, how do we develop good policies? And the question was about working with local government on personnel policy. We have a couple who have, based on past experiences, in particular around insurance coverage and that, where the library had to, or basically needed to adopt the local government's personnel policies as their own in order to continue insurance coverage. This is probably something that you might be familiar with from a couple of years ago. So, the basic question is, do county libraries or, local libraries have to have their own, or are they compelled to adopt their local government's policies? That's a big question.
It is a big question, and it's one that we could spend quite a bit of time on. And I think in the limited time that we have here, and the hope that I always have and try to promote is that sense of collaboration, and it requires an acknowledgement from the local government that these statutes exist and that the library is a unique statutory entity that does have, through its board, a specific operating power. And I understand in the perspective of the local government, the library likely understands the perspective of the local government that, well, we want to be as consistent as possible with our human resources operations. And so how can we create and carve out a different process for one department? And it's important to then stop that discussion and remind everyone that this is not just another department within the municipality or the county. This is a unique entity. And so we're not asking for specific exceptions or exclusions. We're asking for collaboration. We're asking for acknowledgement that these are unique situations that require unique solutions. And when that discussion starts, and it starts with that tone, I find that that there can be a better chance for collaboration, topic of solutions. No one wants a lawsuit. No one wants a litigation. No one wants to have to go to a mediation about what law means what when it comes to how this particular issue is going to be resolved. Instead, for the good of the community and the people that live in the community and the people who are paying for this particular service, it's in everyone's interest to work together to acknowledge that the library is unique, while also acknowledging that the county or the municipality has unique needs with regard to its efficient operation of staff. And so it comes back to the interlocal agreement, setting forth the terms as to how that will occur. And then once you have that spirit of collaboration through the local agreement, then building upon it to set forth how the library, as a unique entity, both in terms of what the law says and the services that are provided, has policies that reflect its status as a unique entity. That's probably easier said than done, and there might be some that are saying you're being naive, but I know that's the spirit from which we have to start the discussion. And once that is emphasized and understood and respected by both sides of the discussion, then there can be some movement forward, and that's our hope, and that's the process that I would always advise when starting, is that that diplomatic effort, it can be useful in building an atmosphere of transparency and trust in those operations. Can go a long way to getting that mutual respect. So that's the way I would phrase it, and the hope that I would instill in everyone that it can be done. And using, as you mentioned a few years ago, some of the disputes that occurred that became public and the basis for Montana Supreme Court decisions. Let's avoid that, and let's save everyone some time and money and distraction and heartache by making sure our community's governance is unified to meet the needs of our neighbors.
I think that's really, really good, Chris. Like you said, it's a big topic. And so, in the spirit of collaboration and cooperation, grounding yourself in your library type, your library governance model, understanding the authority of the board as you've laid out over the course of this series too, in terms of adopting personnel policy, adopting the policy clearly sits within the authority and responsibility of the local board. So, and jump in if I'm saying something incorrect, but in collaboration with your local governing authority, to be able to develop those policies that are consistent, that help make it clear to employees of the library, what their terms are of employment and their protections and those sorts of things. So it's never as simple as this is our side of the fence and that's your side of the fence. It's always, let's work together so that there is that consistency with law and that we can all act in the way that allows us to get this work done consistently with our mission too. So I think we
Exactly.
could talk about this a lot more
Yep.
in other times.
Yep, that's for sure. And I'm available for any type of conversation or discussion about it, and how to try to start those collaborative discussions. And there may be situations where um, the local government would realize maybe their practices and documents may change based on the perspectives of the library, and with always the goal of making sure government is accountable and transparent, at all levels and all facets. And that should be everyone's goal, to make sure it's responsive to the taxpayers and the citizenry, and also to just avoid the distraction of litigation. And all it would take is for some employee to not have their rights honored, and then the county or the municipality, the library is entangled in some kind of unnecessary legislation or litigation because of a gap in the policy, because of an unnecessary uh, dispute between the library and the local government. So let's just avoid it, and let's work together and make sure that um, we don't have those types of issues that distract from our work.
Excellent, excellent. Thank you so much. I don't see any other questions coming in right now. I did share our event evaluation in the chat, so we really appreciate it when folks will fill out that very, very short form. It helps inform our next steps and how we move forward. Chris, as always, thank you so much for spending time and all of the work that you do to prepare for these sessions. I'll be posting the recording, a summary, and resources from today's session a little bit later on this afternoon in our Aspen event. And of course, I will share out more information in our newsletters and and if you give me a call or whatever, anybody reach out and we'll get you the information that you need. So thank you so much, everybody. Have a great rest of your day.
Thank you.